SJC-12059. Clifford E. George v. Jacqueline A. George.
Thank you very much.
Mr. Kelly, good morning.
Good morning, Mr. Chief Justice, Your Honors. If it please the court, my name is Brian Kelly, and I'm here representing Mr. Clifford George in this matter. Your Honors, this is a matter regarding the Alimony Reform Act. This is a situation in which there's a challenge to the Section 49 of Chapter 208 regarding the durational limits to the Alimony Reform Act. Without getting into all of the facts as far as that, I'll just get right over to the case. And in this particular case, the issue at hand has to do with husband's challenge to or complaint for modification to terminate alimony under Section 49.
Just for starters.
Yes, Your Honor.
You don't disagree that it was premature, do you?
Well, one, I didn't argue that, just to be clear, Your Honor. There is argument one way or the other,
Well,
but I
under
can
the
see
Holmes
both
footnote.
sides, Your Honor. I will be fair. I
Okay,
can
but you
see
don't
both
argue at
sides,
A,
but
and B, the Holmes footnote may not reach it, so.
yeah, so I'm basically just arguing the rationale of the trial judge to deviate from Section 49 for the reasons stated, and I did not challenge. I didn't concede it, but I didn't challenge it, Your Honor.
So even if we disagree with you with respect to the judge's rationale, your position is this has to be reversed anyway, or do you not argue that?
I'm not arguing that, Your Honor. To be fair, I can't argue that. Like I said, there is an argument to be made that under Section 5 of the Act, I call it a grace period in which these durational limits can be brought, and the only exception is if there has been a challenge.
Right, that's the Holmes footnote part, right?
I'm sorry?
That's the Holmes footnote part?
Yes, yes. I mean, the two sides of this is that, well, the husband in this case did bring other challenges, did bring other issues for the modification. Trial judge basically dismissed them out of hand. So the question then becomes, well, does that make it the sole issue? Because it was, I mean, obviously you can't just come in with something foolish, I would say, and then say, well, but I also got this, so I'm going to circumvent the time frame.
Right.
I'm not conceding that the argument was foolish by any means, Your Honor, but so there are pros and cons to that, but we're not arguing that
Right,
here,
but I
Your
mean,
Honor.
but realistically, if you were to prevail, we would say that the reason given would not be, if we reach that issue, we would say the reason given is not appropriate. You would then reapply,
Yes.
which would now be timely, and then you would use the guidance from our opinion to make your argument going forward.
Yes, as a matter of fact, there was a timely reapplication for this, but that was dismissed under res judicata, saying this has already been the issues on the merits. And essentially, because that was correct, because at the time that was the ruling, I didn't appeal that. And that's the reason why in my conclusion to the brief, I said, you know, I'm looking to have the court reverse the merits of it so that then if it gets remanded and they finally say, okay, yes, then the kind of breathes new life into the timely filed.
Well, if you're suggesting that, what standard for deviation from the durational limits would you suggest for the Alimony Reform Act?
I'm sorry, you know.
What standard would you suggest for deviation
Well, I mean,
from the durational limits?
Well, in this particular case, Your Honor, I'm basically, the argument is that there was an abuse of discretion and it was plainly wrong. In that one, the issue presented because there were no testimony, there was no evidence, essentially. It was
It was
all.
a joint statement of the parties?
Yes, Your Honor, there was.
And did that speak to anything other than the basis on which the judge found for the wife?
The only thing in the joint statement was pretty much the, I guess you'd call it straight vanilla. They were divorced then, they did this, they did that, but there were no statements, no assertions by husband conceding anything.
Well, let me ask you more particularly, was there information before the judge regarding, I think that in the wife's brief, there's some indication that the wife has health issues. Was that before the judge?
It was brought by wife's counsel, but it was not entered as a reason or a
No,
rationale.
I
for
understand
the-
that the judge didn't use that, but I'm saying, was that before the judge?
It was brought before the judge.
Was in the form of something in the joint statement of the parties?
No, it was not, Your Honor.
So
It
that's
was-
the only evidence that was before the judge?
The only evidence is, yes, Your Honor.
So there was no evidence regarding anything other than the basis on which he reached well, and you're contesting that there was basis for that, but I'm just saying that, following up on Justice Lowy's question, what would constitute adequate basis to deviate from the durational limits?
Well, I think wife has a tough time here because
Well, not
this was
just here, I'm talking generally. I mean, would something like a health issue that has arisen after the parties' divorce agreement is in place and the judgment's in place, would that constitute a basis to deviate if it was significant?
I believe it certainly could, Your Honor.
It could.
It could, and
Okay.
I say that because I make specific note in my brief that even though that was brought to the judge's attention, the judge's rationale for deviating from Section 49 dealt solely with the issue of what they call an intertwining of the.
Right.
But
But
never.
there was no evidence before him on anything else either. It
But it was argued.
Was argued, but
And
there
it
was
was
no
never,
evidence.
it was never acted upon. There was never a mention in the judge's rationale that that was also a figure.
So are we basically saying that what warrants deviation in the interest of justice is essentially the same thing as a material change of circumstance under the extant case law?
Yes,
Okay.
I believe
But
so,
I mean,
yes, Your Honor.
material change of circumstance.
Well,
from-
there's a-
I mean, first of all,
there is a
I
material
think- I think
change.
you're wrong about, I'm looking at R46, which is the joint statement, which says the former wife is unemployed and receiving disability income as she is disabled. So
And she was.
that was before the judge and was an agreed upon fact.
Yes, Your Honor.
It was not apparently the basis for the judge's
Correct,
decision, but
correct,
it was
yeah, that's-
there. I mean, change in circumstances from what?
Well, the material change in circumstance is basically what's allowed under the Alimony Reform Act.
But then the Alimony Reform Act says unless circumstances warrant not doing that.
Correct.
So among the circumstances that might warrant not doing that, presumably health would be one of them.
Well, I would agree with you if, Your Honor, that was mentioned, but there was a
Well, no,
ration.
I'm just theoretically.
Yes, theoretically, yes, Your Honor.
And theoretically, would you agree that the reason that the judge did give, and I appreciate your argument that there's no evidence, but let's just assume there was evidence.
Yes, Your Honor.
That this was a negotiated, that the July 2026 date was a negotiated date precisely because of the reasons that the judge surmised, that is, or that somebody argued that because that's when the mortgage was up and that there would be no more mortgage payments, et cetera, et cetera. Would that be a reason to deviate, do you think?
Not necessarily, no, Your Honor. But first, I should respectfully add that there was no evidence that the only, as obviously I probably said ad nauseum in my brief.
No, but I'm just sort of saying theoretically, would that, assume there were that evidence, would that be a basis, do you think, that a judge might say, no, I appreciate the fact that this marriage has exceeded the durational limits, but I'm finding that in this particular circumstance, it is not warranted to change the alimony.
I would respectfully say no, Your Honor, because, and here's the reason why. Just like every other divorce, whether the divorce comes about because of an agreement or comes about because of a judgment after a contested trial, there is negotiation in everything. And, you know, for the judge in this particular case to have said, well, had wife known that this Alimony Reform Act was going to come and basically put the brakes on all these things, she would have done everything. She may have argued for some difference in negotiation. Well, I would assert to the court that that would happen for everybody. You know, if the justices in the probate court had known that this was going to come out, they probably would, if they're the ones deciding how much alimony a recipient spouse should get, they would have done it differently too. And again, I suggest that that's why Section 5 of the Alimony Reform Act, where it basically gives this grace period that's not just, okay, as of today, we're going to draw a line in the sand and all alimony is going to stop, that the legislatures have come up and said, okay, well, we're going to, you know, if that kind of goes to that prematurity issue, we're going to have it, but not until 2013, 2014, 2015, and the like. So just because it was negotiated, I would suggest to the court that they're all negotiated, whether it be negotiated in a justice's mind, deciding what he or she is going to rule as this is what the alimony is going to be, or negotiated between the parties.
Well, is the Alimony Reform Act in itself a change in circumstances, or does it have to be something after the durational limit?
I believe it's, the Alimony Reform Act specifically says that, the durational limits are retroactive, the only part that is retroactive, because in and of itself, the durational limits are considered a material change of circumstance such that nothing else need be brought other than the fact that that exists.
Suppose that now parties are getting divorced and they're drafting agreements and so on and so forth, and suppose parties put in something like, notwithstanding the provisions of the Alimony Reform Act, thus and such section, the parties expressly agree, and specifically agree based upon property division and blah, 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 whatever else, that alimony shall continue for a period of 25 years.
I would think that would be perfectly permissible. Your
And if someone comes in and says, well, you know, the Alimony Reform Act doesn't permit durational limits like this, that's not a problem.
Well, what I would say to that, Your Honor, is the Alimony Reform Act specifically states that all alimony judgments that are existing prior to the enactment are considered general term alimony reform acts. And what the statute says is that the Alimony Reform Act is any judgment that from prior to 2012 that exceeds the durational limits may be
Modified.
So it talks
Yeah.
about
No,
the
I
ones that are
understand that.
already in place. As Your Honor says, if the parties decide to draft around that,
So that has to do with, my question has to do with drafting around it. I think what's typical in these kinds of agreements is the death or remarriage provision, which seems somewhat generic.
Right.
What's probably struck the judge as unusual here is that there was a specific date entered into also.
right.
So that one might look at that as an attempt to draft around, and for the judge to say this is specific, not generic.
Well, what I would say to that, Your Honor, is that I'm looking strictly at the statutory language, which says that alimony judgments that exceed the limits of the Alimony Reform Act are considered general term and are subject to being.
Yes, but
you
the
know.
judge can make an express finding that permits deviation for some reasons. And I guess what we're trying to do in part is figure out what those reasons might be. And so what you've basically said is I think, that if we look to traditional material changes of circumstances, what would constitute that, what we've recognized as able to support a modification, that would be the same thing as what would warrant a deviation.
Well, the other thing that I agree with you, Your Honor, but the other thing that I would just suggest in my couple of seconds left here is that the whole premise of, well, again, there's no evidence as to all the intertwining and this dealt with that is all just brought up, not in evidence, but by argument of wife's counsel. But if you really look at the practicality of it, that what wife is arguing is that wife agreed to take alimony for a shorter period of time in exchange for taking less. And which
Well, if you.
doesn't make sense.
Well, if you posit that she doesn't think she's going to die in that period of time, and she doesn't think she's going to remarry, so she's limiting it.
And I would suggest to you, Your Honor, and point well taken, of course, Your Honor, but what I would suggest is that she could have also, again, we don't know, but she could have also said she got the house. She got the biggest prize there, and she could have gotten, we don't have the figures, but more money. So she could have actually bargained to get a higher alimony rate and more in the property in exchange for letting it cut out.
Right, but I mean, is it unfair, I mean, 49B, with regard to a judge who is setting it going forward, says you may deviate if required in the interest of justice. Do you agree that where it's done retroactively, a judge may deviate if it's in the interest of justice?
Of course, Your Honor.
Okay, and do you agree that in doing that, a judge would look at what the change would mean in practice for the husband and wife
I agree
at
with
that
that
point
also,
in
Your
time?
Honor.
So if this were filed timely in 2015, the judge would say, okay, if we are going to basically cut off alimony for the wife, is it in the interest of justice to leave the wife right now without the financial benefit of alimony? And I need to look at all of the circumstances to see if that would be fundamentally unfair. That would be an appropriate analysis in your mind?
That would, Your Honor, and I would totally agree with you, but for the fact that in this case, the judge, having given a rationale,
Right, didn't do
never
that.
put that in.
Okay,
The
I understand.
rationales that the judge gave do not hold.
Okay, so you would say that, so what you're essentially looking for then is to say, okay, it should have been filed later, I'm going to refile, but you want guidance from us to say that when you or anybody else refiles, this is the analysis that a judge should entertain in examining whether it's fundamentally unfair to permit alimony to be cut off pursuant to the
Right, I mean, the
to the
worst thing that
durational
happens to us as appellate counsel is to have to argue before the appellate, either you or the appeals court, and we don't have a reason. And then usually the learned justices can come up with 100 more reasons why the judge went the way they would. In this particular case, there's a written rationale. And my point to the court is, if there's a written rationale, and there are other rationales that we're all discussing today, but it's not in there, then that was not considered. And I asked the court to look just at the rationale that was given in this particular
So
case.
do you think there's enough of an evidentiary record to apply whatever standard is going to apply for a deviation?
No. No, Your Honor, I don't.
Okay.
If
there are
there's
no
no other
if there are
questions,
no
I'll
further
rest on my
questions,
brief,
I
and I
will
thank the
thank you.
court for their time.
And you can note in your biography that you were the first person to argue before Justices Gaziano, Lowy, and Brown.
It's an honor, thank you.
You're the second.
Counsel, before you get started, let me ask you about the timing issue, because I know everybody else is concerned about the standard issue. Did you object to the judge's ruling on that basis? I am concerned that if we get to the merits of this case where the prematurity is pretty apparent, that may be a problem in the future. People may feel that they don't have to abide by the statutory time limit. So what was the case made before the judge in making his decision on this issue? And how did it happen that the judge just ignored the prematurity issue and went straight to the merits?
Well, I don't think the judge did. The judge did analyze the timing of the complaint for modification in this matter, and it was raised as an issue that it was in fact premature in terms of the filing. So I think that was before the court, and I believe in the judgment it discusses that within the record, and I think it was also raised as part of the brief. I think what the judge did here was he analyzed specifically all the grounds available to the payor of alimony, the appellant in this matter, to figure out whether or not there was a substantial change of circumstance that would require a modification of the alimony award. I believe he looked at whether the durational limits could be deviated from as imposed by the new statute. So I think everything was analyzed here.
I thought his reason for getting into the merits was that he was concerned that maybe that footnote in Holmes, because you had raised these other issues, not you, because the husband had, that maybe that it would be ripe to consider the alimony modification.
I think that was in his mind. I think that he wanted to be, as Judge Stalin, as he is, wanted to be as thorough as he possibly could, and to give the benefit of the doubt to the payor, to give him an opportunity to make his case under any reasons for stopping the alimony payments to the payee. I think that he was concerned with the new statute. I think that he wanted to see also whether there was a material change of circumstance. In this particular case, he found, I think, that there isn't a material change.
But let me ask you about that. Sure. Don't you think once, forget the timing, let's just assume that we're now past March 1, 2015, and the husband comes in with this request to change the alimony. Doesn't the burden shift to your client to prove that justice demands that there be no change? I mean, it seems to me that the judge, and certainly you argue that this remains the husband's burden, and I don't see that.
Well, I disagree. I think that the legislature here, and I think this is an important note, has granted broad judicial powers to probate court judges to analyze agreements that come before and predate the new Alimony Reform Act. And I think the reason why that is because, and it's expressly made clear in the legislation in 3 parts. At first, we talked about 4B, the uncodified provisions. It says, shall be modified without additional material change of circumstances unless the court finds, and this is what's key, that deviation from the durational limits is warranted.
Well, that's my point. Doesn't that then go to the wife to show that deviation isn't appropriate?
I think that in terms of the burden, yeah, I would agree with that. I think that as long as she can show that deviation is warranted, I think that's an acceptable form. And I think that 20849, in addition, when it talks about interest of justice, I think is speaking, I think the statutes are all connected. I think that 20853 gives the greatest guidance here, because when you harmonize these 3 statutes, what the legislature is doing is they're saying to probate court judges, look, you cannot have a blanket rule that pre-existing agreements to the Alimony Reform Act that survive in part and merge in part for alimony should be shut off. I think that would be fundamentally unfair, and I think that would be not within the interest of justice. And I think 20853 is very illustrative. It gives and sets out 9 criteria of which a judge can deviate. So I think it's giving us some guidance here.
Where are those criteria?
20853. It gives 9 particular criteria, and I would point out here that it gives out reasons of health, tax consequences, and age of the parties, sources of amounts of unearned income. And I think what's very important here is it says grounds for deviation may, not shall, may include. So this is not an exhaustive list of factors. And it says on number 9, upon written findings of any other factor that the court deems relevant and material. And I would submit to this court that a pre-existing agreement where alimony merges, that alone is a grounds for deviation when there's a bargained for end date.
Well, don't you need evidence of the bargained for end date?
No, because it's in the way I think Judge Stalin looked at this and the way I think it makes sense going forward for probate courts to analyze this is that it says it right in the agreement. You know, parties are encouraged within the probate courts to come before and bring agreements. This agreement, there is always a connection between alimony and property.
What was the source of the judge's finding that the property distribution impacted the negotiated durational limit?
I think that the source was the agreement itself. What was before him was the agreement. And what he
Nothing in there that talks about July 30, 2026, tied to the end of the mortgage. There's nothing in the judge's findings. There's nothing in
No,
the
that
joint
was-
statement. So you have to really go outside the evidence to somehow tie that to the end of the mortgage.
I don't think so, and here's why. I think that it's Justice Gantz had written in the Pierce case. If Mr. Pierce had warned his alimony obligation to end on a date certain, he could have negotiated a different provision in the separation agreement. In the Chin case, we talk about judges needing to take heed of the parties' own attempts to negotiate terms mutually acceptable to them.
But wasn't that fact plucked out of the counsel's memorandum? It wasn't part of any affidavit?
No, but I think it's a reasonable inference. I think that judges know about the connection between alimony and property division in the probate courts. They're not mutually exclusive items. They go hand in hand. And I think the legislature has made that clear too, because what the legislature has examined is that they have said that, the standard that was in place when these parties got divorced are the same set of factors. 20834 was the same alimony factors at the time these parties got divorced as the time for property division.
Well, that's true in every case, isn't it? I mean, that when you have an agreement, you're thinking about the future. I mean, how is this statute supposed to work if every agreement that is subject to it, you can't change it because that's what the parties wanted to do when they did it? I mean, what's the point of the statute?
Well, here you go. I mean, I think that's the rub. Is here, Mr. George had the ability and still has the ability to bring a modification under the same sets of rules that were in place at the parties.
That's not his burden. He's got the changed circumstance. He's got the fact that the durational limit is over.
But the rule, it should not be that every single merged agreement of an alimony where a property division survives is subject to retroactive effect.
Why not? That's what the statute seems to say.
But that's not what Chin says. I mean, this court has held that may, but will not always be applied retroactively. And this is precisely the type of agreement that this court, for fundamental fairness, should uphold the judge's reasoning. Because what he's saying is, this is unlike many agreements. Many agreements just say marriage upon the wife's remarriage, if it's the wife that's the payor, or death. This agreement, which makes it special and unique, is it has a bargain for end date. And
But the judge opines a whole lot of facts that maybe they're true, but there's nothing in the record that would support them.
Well, I think what supports it is the end date, because that's what's unique. That is what is unique here, is that end date. In fact, the legislature in the legislative history talks about how this will not affect prior agreements except for those that go on forever. That's in the Rodman case. What makes this different is that bargain for date. This was a date that the parties bargained for, and it's as if we're going back in time and saying, okay, to use a sports analogy, that in this basketball game, one team scored 3 points, more three-pointers, and lost, and now, years later, we're going to make those three-pointers count for 5, and the game changes.
Would you agree then that if it had just said death or remarriage, the game would be over as far as the wife is concerned on this record?
I think I would. I think that what makes this unique is the bargain for end date.
Well, we assume it was bargained for because it's in the...
It's in the agreement. I think that's a reasonable inference. I think judges need to have discretion here to make reasonable inferences based on the facts that are before them.
But isn't death and remarriage a bargain for end date?
It can be, sure. But here...
I mean, why can't you be sure? It says
Well,
this
well, it
continues
is. No,
until
absolutely. No, I
basically you
agree,
die or
sure.
remarry. That's a
Certainly.
bargain for end date.
Certainly.
So it seems as if all these agreements have, I mean, my concern is that if you are right, there is the danger that the exception is going to devour the rule, that you can always say, well, golly, if they had known when they executed that agreement that this new law would basically limit the duration of alimony, they would have done something differently, and therefore we're not going to allow that to happen,
Well, I think.
because that's unfair. But I mean, if that's the case, the whole structure of the statute to provide for retroactivity is essentially undone.
Well, I see the point, but I think that what we're asking for is on a case-by-case basis, a judge be afforded the broad discretion that he's handed to or she is handed to by the statute. And I think the statute is very broad in terms of deviation.
But wouldn't it be different if the judge had said, we're going to look at the present circumstances and see if it would be fundamentally unfair? And the fact of the matter is, although she has the house, she's still liable for the mortgage for 10 more years. And therefore, I think it would be unfair to cut off the alimony because she's using the alimony money to pay the mortgage. That would be looking...
Disabled.
And she's disabled and doesn't have the ability to earn anything or much. That would be looking at whether it's fundamentally unfair today to do that, not whether or not they would have cut a different deal had they known that the law would change.
Well, and I think he could have done that, and I think if it goes back, that's exactly what will happen, and that'll be what'll be the rule. But I would argue, and I think that it's important to take heed to the fact that these parties entered into this agreement prior to the Alimony Reform Act, and that the statutory language here gives such broad discretion, and I think that it is relevant and material when you're looking at these two statutes, 208-48-55 and the traditional 208-34, that go hand in hand. So I think that the other thing that I think is important on this particular record is that the judge did say in the judgment relative to the attorney's fees that there was no disputes of facts. He said that there was nothing in the record that was in dispute between these parties.
But his rationale has facts for which there is no evidence. Maybe they're true, but I mean, why do we have to accept that as fact?
Well, I think in this particular circumstance, which does happen in the probate court, there was an agreement in place to submit papers and argument rather than go to trial, which is something that happens all the time.
Well, you could have affidavits. I mean, the probate court isn't some cowboy out there. It's part of the court system.
No, absolutely, that's true. Although some people might disagree with that, but no, that's absolutely true. But I would still submit
But the parole evidence rule still applies, right?
Well, I think the four corners of the document, I think I still would argue that it's a reasonable inference.
But if that
in a
was
separation agreement that talks about health insurance, that talks about property division, that talks about a house and who's going to pay for it, that bargain for date makes this more unique. And I think let me just say one more thing. I'm sorry. If the rule is that a judge, I think it's a dangerous line here for this court to go in the opposite direction here. Because if what Justice Gantz's point is that we're going to subrogate the statute, here's the problem. If you say that a merged alimony agreement and a survived property division, that in those circumstances, that the rule is that it is subject to retroactive effect, what you're really doing is you're slicing this statute and making judges and robbing them of the great discretion the statute has.
Are you saying that because there's a surviving portion of the agreement that is pivotal here?
I think it is.
That means that the judges have a different rule for such
I think
statute doesn't apply somehow to those kinds of judgments?
Well, I think the connection is what is germane here, because the problem is Mrs. George can't go back and change the property division because it survives, whereas Mr. George always reserves his right to go back to the probate court because of a material change in circumstance. So he's protected, she is not.
But doesn't that assume that they're tied together and that's based upon facts that weren't properly before the judge?
I think based on everyday probate and family court life, when there's a separation agreement before the judge that contains all the facts and all the bargains that the parties have agreed upon, and that includes a bargain for deviation date, I would submit to this court that that's enough evidence based on to not apply this statute retroactively
Let me ask you
in
this.
this particular set of circumstances.
Are you saying that the judge didn't need to he could have simply said, look, this agreement has this July 2026 date. That's the end of the subject. that he didn't have to go on and opine about, I mean, is that what you're saying? That every agreement that pre-Alimony Reform Act agreement that had an end date for alimony, that's sometime still in the future, that trumps anything else?
Regarding the statute, yes. And the reason is because they can still come back when it merges to show a material change of circumstance. That is fundamentally fair, and that would give probate court practitioners, litigants, and judges the right way to view pre-existing separation agreements.
All right, thank you.
Thank you.